Hello everyone, my name is Patrick Shalvey, and today I will talk about two of the earliest stages of the life of a lawsuit, and those are complaint and answer. First off, before the complaint is even drafted, the attorney has an obligation to investigate the facts of the case and conclude that there is a sound basis in law and fact for the pleading. This is a very important step because if it is not met, the court can impose sanctions against the attorney. So if the attorney completes this step and concludes that there is a sound basis in law and fact for the pleading, they can draft a complaint. Every complaint contains different things, but generally a complaint will contain three things, which are a statement showing subject matter jurisdiction, which can mean either federal question is satisfied, meaning the case is based on federal law, or diversity jurisdiction, which means that the plaintiff is from a different state than the defendant or defendants, and that the amount of controversy exceeds $75,000. The second statement lists the claims, which show that the plaintiff is entitled to relief. And the third is a statement of relief requested, which is known as a prayer for relief, which typically comes at the end of the complaint. All the statements in the complaint should be concise because further details will come out in later stages of the litigation process, and each statement should have its own paragraph. The complaint should be very organized. This is very, very important. Accompanying the complaint is a summons, which is a notice that commands that the defendant appear and defend against the complaint within a certain period of time. Now, generally, again, this depends on a lot of different factors, but generally the defendant is given 21 days to respond. If they don't respond, then the court issues what is called a default judgment against the defendant, and the defendant doesn't have a chance to even defend him or herself. There are three possible answers that can be given. The defendant can either admit to the allegations, deny them, or state that they are without sufficient knowledge to admit or deny them. It is very rare for the defendant to admit or deny all of them. Generally, each allegation in the complaint is answered individually. One of the ways that the defendant can admit to an allegation in the complaint is by issuing what is called an affirmative defense, which is a way of admitting to an allegation, but also not showing that the plaintiff is entitled to relief. So these are the basics of a complaint and answer part of a lawsuit. Obviously, there's a lot of different things that can go into it depending on what type of case it is and things like that. A lot of different factors can go in, but these are the very basics that every lawsuit should have contained in its complaint and answer. Thank you very much for watching.